Participants Ethan emphasizes historical support for an individual right to keep and bear arms. Miles emphasizes the long tradition of regulation and civic purposes. Ethan, when we ask what the Second Amendment meant, we need to read it the way lawyers and citizens in the founding and 19th century read it. The operative text says, "the right of the people to keep and bear arms." That phrase, "right of the people," appears elsewhere and it means an individual right. The prefatory clause about the militia explains one reason the right matters, but it doesn't narrow the right to militia service only. Plenty of early sources treated keeping and bearing arms as a personal liberty. Miles, the same early sources also reveal a civic dimension. The very words, "well regulated," are a reminder that the founding generation understood rights alongside duties. Militia statutes required musters, inspections, and storage rules. Towns regulated when and where weapons could be carried. The historical baseline isn't anything goes. It's a right embedded in a community that set constraints to protect the public. Ethan, I agree the founders regulated many things. But that strengthens, not weakens, the individual right reading. The reason to regulate is because a protected individual right exists and has to be reconciled with other interests. In the 19th century, courts and commentators often described carrying arms as a personal right, especially openly, while still allowing limits on concealed carry or dangerous conduct. That's consistent with a broad right paired with targeted rules. Miles, but look closely at the pattern of those rules. Urban areas often imposed stricter limits than rural areas. That's not random. It reflects a tradition that treated weapons in crowded public spaces differently from weapons in the countryside. If we pretend history is purely about an unrestricted individual right, we erase the very variations the sources emphasized. Ethan, no one is erasing them. The question is hierarchy. The weight of text and many historical practices point to a personal right as the default. Regulations then need to fit within that tradition: time, place, manner, sensitive places, dangerous and unusual weapons, licensing that ensures competency. That's a structure with the right on top and limits justified by historical analogues. Miles, I'd phrase it differently. The historical structure is a dual commitment, to a right and to the public order. There's also a contested narrative about motivation. Some historians tie the amendment to Southern concerns about control over slave patrols. Others dispute that. The existence of that dispute itself counsels humility. Our present-day frames can color which sources we elevate and how we read them. Ethan, humility, yes, but not paralysis. There's strong evidence that many Americans, early and late, saw the right to keep and bear arms as personal. If we're faithful to that, modern law should protect ordinary, law-abiding people who meet competent standards. Think of the 19th century cases that uphold open carry while permitting restrictions on concealed carry. That's a practical balance with deep roots. Miles, and faithfulness to history also means recognizing regulated spaces. Courthouses, polling places, schools, locations where the presence of weapons threatened public life. Those limits weren't afterthoughts, they were integral. Through that lens, modern, sensitive places, rules have a respectable pedigree. The public square can be protected without abolishing the underlying right. Ethan, then we might be closer than it seems. I'd accept sensitive place rules that hew to historical examples and aren't used as a pretext to ban carry everywhere. I'd accept licensing tied to objective competence, training, safety, legal knowledge, with quick, fair processing. And I'd support safe storage rules that echo historical duties to keep arms in good order. Miles, and I'd accept that the standard can't be a living veto power. Historical inquiry must be principled, looking for analogues at the right level of generality, not cherry-picking. Where the tradition is mixed, courts should ask whether a modern regulation protects the same kinds of interests: order, safety, prevention of terror, by comparable means and burden. Ethan, that's the crux: comparable means and burden. A rule that effectively strips ordinary people of the ability to carry for self-defense doesn't look like a historical analog. A rule that focuses on crowded venues and high-risk behavior does. As for weapons types, the tradition drew lines around dangerous and unusual, translating that today means drawing lines carefully and transparently. Miles, carefully and transparently, and with respect for the differences across communities. Early America had local variation. Today's doctrine can honor that by allowing denser places more leeway where the record supports it, and by recognizing broader protection in rural settings. The point is to let historical judgment inform modern calibration, not to turn it into a slogan. Ethan, let's make it operational. Keep an individual right to keep and bear arms for lawful purposes, including self-defense. Allow regulations with deep historical roots, sensitive places, objective licensing, storage duties, limits on especially dangerous and unusual weapons. Require the government to carry the burden of showing that a modern rule fits the tradition in purpose and magnitude. Miles, and let's add process, accessible training routes, prompt licensing decisions, and judicial review that takes historical evidence seriously but doesn't pretend it's a math equation. When the record genuinely supports both sides, courts should avoid absolutes, narrow their holdings, and leave room for democratic governance within the outer bounds of the right. Ethan, in other words, a constitutional settlement that remembers the amendment is both a shield for individuals and part of a constitutional architecture for public peace. If we do that with integrity, we can reduce conflict and improve safety without treating the right as either untouchable or illusory. Miles, exactly. The history is richer than advocacy briefs suggest. If we let that richness guide policy, right plus responsibility, liberty plus order, we honor both the text and the lived tradition it came from.